Hello, everyone. Thank you for tuning into this Your Overseas Home webinar, in which we're focusing on inheritance tax and how it applies to expats in Spain, and how that then applies to your estate, and how you can safeguard it and protect it for your heirs and your beneficiaries. So we're going to be talking about that, but it's a lot of what we talk about is also applicable to expats in other countries, but we are going to be focusing on people moving to Spain today. I'm Richard Way from Your Overseas Home, and I'm hosting this session. It's great to have you all with us, whether you're watching live or you might be watching our recorded version, which is available through the events page on our recently revamped website, which means you can go back and watch this again after the live broadcast. So if you're watching, chances are you're considering, or maybe you're even ready to move to Spain. But before you head into the Spanish sunshine, have you thought about what happens to your estate and your financial assets as a Spanish resident, having lived or been domiciled in the UK or another country around the world? Have you taken important steps and put in place safeguards to ensure your wealth is protected, structured tax efficiently, and is in a structure that means it will get passed to your chosen heirs without causing them any problems? So if you're unsure about any of this, you're in the right place. In this session, we'll be covering all those need-to-know facts about Spanish inheritance succession in relation to the new IHT taxes and rules in the UK. And sharing all this valuable information today, it's not me, but it's our specialist speaker, who is Robin Thornton from International Financial Services, Holborn Assets. Robin's an experienced wealth manager. He's based in Spain himself, and his day-to-day work's helping expats who come from all over the world, not just the UK, with cross-border wealth management, asset protection, taxation, and even visas. So welcome, Robin. You can hear us loud and clear?
Loud and clear, yeah. Thank you very much for that introduction. Yeah, thank you.
Okay. We've got about 45 minutes for this, and I know you've got a presentation to show us, Robin. We also want to hear from anyone watching. It's a good opportunity to ask questions directly to Robin. He's given up his time to speak to us from Spain. So if you've got a question, you can use the questions tool that you should see on your dashboard. If you just type it into there, and then I'll pick it up and pass it to Robin. I'll wait at least till the end of his presentation to ask them, just so he has time to get through it. Okay, that's enough from me for now. Robin, over to you. The floor is yours.
Great, thank you very much indeed. And for those of us, those people who have joined this channel before, so my name is Robin Thornton. I'm a chartered financial planner. I'm a partner at Holborn Assets. I'm based here in Spain, and it's 29 degrees today. So I think you said it was about 15 in the UK, something like that earlier. Anyway, so yeah, so I might be a little bit smug at the moment, but you know, we still need some rain, and we haven't had any since April. So, but yeah, so what I'm going to run through today is, shall we say, guidance on the changes into the inheritance tax laws in the UK and how they revert and how they are applicable to overseas residents, and one or two of the opportunities that exist as well. So that's the key to this. Now I'm going to start with a disclaimer, which is this is not tax advice. It's very, very important that you take professional advice, and we can provide that, and we can link you up with various people. We are financial planners, so this kind of dovetails in. I always like to think of us as maybe a GP when it comes to medicine, and if you need brain surgery, well, we'll send you to a brain surgeon. But always take personal advice. So this is guidance, it's not advice. Okay, so this is what we're going to run through today in terms of topics. Fairly straightforward. Again, going to keep it fairly generic. Just understanding, first of all, what UK inheritance tax is. A little bit about the general thresholds and exemptions that you can get. Some of the strategies, again, generic, for reducing that or mitigating it in some way, and how that affects people on an international basis. A lot of people are unaware that you might be living here in Spain, for example, but they could still be subject to UK inheritance tax. And some of the kind of do's and don'ts, shall we say, practical steps and common pitfalls that people fall into. So first of all, what is inheritance tax? Okay, pretty straightforward, but on the death of an individual or the second death of a couple, it's basically a tax on the estate value of the deceased. Okay, and that can include previous gifts that have been given away and other bits and pieces. I don't want to get too much into that, but there is what we call potential pets, which are potentially exempt transfers. I'll come on a bit more to that later. And basically, it currently, or should I say in the past, was domicile based. So everybody with a UK domicile would potentially be liable to UK inheritance tax, regardless of where they live in the world. Okay, and that's really, really important. However, that's what's changed, or that's one of the changes. Okay, so a little bit more detail what this inheritance tax is. First of all, you've got what's called a nil rate band, which is £325,000, where it's like a personal allowance. That's your, we're not going to tax you if your assets are less than that. Now, it's been frozen at that level since, oh my God, I'm going to say it's been frozen for probably 10 years now, and it's written into legislation that it will remain frozen until 2030. So it's catching more and more people as people's assets, primarily their homes, grow in value. You get 175,000 extra for if you leave your main home to one of your direct descendants, so basically the kids. So potentially, if you're married to a UK dom partner, that's really important, you could potentially get £1 million of allowances before you pay any tax. Hey, that's probably not going to affect 90 or 95% of the population or the people who are watching this webinar. However, there are issues and there are one or two things that come into the mix that reduce it. For example, if you're married to a non-dom, so a non-domicile, a lot of my clients traveled all over the world, they've fallen in love, they've married, and they're married to people from Thailand or Spain or the Dominican Republic, I don't know, anywhere except for the UK, because the non-dom spouse doesn't get a nil rate band. Now, anything above the nil rate band is taxed at 40%. And there are a number of exemptions and things that can go in there to reduce it. But quite frankly, not a lot anymore. But there is no tax between spouses. So if I pass away, my wife inherits, and this is if I was in the UK, my wife inherits all of the assets. There's no tax to pay. But then when she passes away, that's when the potential taxable event happens. Okay, so what's changed? I alluded to a little bit there to start with, but it's now changed as of April of this year from a from a domicile-based system, so that, I'm a UK dom. Domicility is based on your passport or where your father was born. So it's quite hard to change your domicile. You can do domicile of choice. Again, a session for something else. Bands have been frozen since, and they will be frozen until 2030. Now, this is the big key here. So the other big change, which is happening next April, 2027, 18 months from now, and that is that they're adding pensions into your estate. So previously, assume I passed away and I had a £500,000 pension, which is not unusual when people have worked all their lives and they've had big schemes. And that would be passed to my beneficiaries outside of my estate. Now, they could be liable to income tax on it, for example, etc., depending on how it's passed down. But it's not in your estate. It's not going to be taxed at 40%. Now, as of April 27, and this is draft legislation, so there may be some tweaks, and I'm sure there's going to be some political infighting. It's going to be added into your estate. So all of a sudden, maybe you've got a nice house that's worth, you know, £500,000-600,000, and you've got a nice pension, £500,000-600,000. You're all of a sudden into inheritance tax thresholds. Okay. The complication with this as well, and again, it's draft legislation, is very difficult. I think it's going to be very hard for people to execute this on their own, because your personal representative has to pay the tax on behalf of the estate and for the pension side of it, and they may not be a beneficiary of the estate as well. So can you imagine, you know, the complexities of that? It's definitely going to be something for professionals, for solicitors and lawyers to be dealing with in the future, I'm sure. Okay, so the big change is this definition of long-term resident, and this is going to affect people who are living overseas, and this is where some of the opportunities might lie as well. So you're still going to be considered connected to the UK for inheritance tax purposes if you were resident in more than 10 years of the last 20 years. Okay, so that's an important factor. So, and again, draft legislation, the plan is you leave the UK tomorrow, it will effectively take 10 years before your UK assets have dropped off the radar. That is if they're not physically in the UK. If you own a home in the UK and keep it there, and you're still liable for inheritance tax on that property. Okay, it's as if, it's like if you're I don't know, I know a number of investors that I'm aware of from the Middle East, and they've bought properties in the UK. They don't realize a lot of the time that they're subject to 40% inheritance tax should they pass away, and there are no allowances. Okay, so it's quite a difficult area, shall we say. So what this brings into focus is people, their residency status and how long they've been away from the UK. And it also kind of dovetails into, for example, a statutory residence test in the UK. And again, that's a whole nother topic. Okay, so what's important? Well, first of all, or what's included, should I say, first of all, it's pretty much all your assets that you would own. Cash in bank, house, the net value of the house. So if you've got any mortgages on there, they're reduced, you know, the amount is reduced by their investments, SIPs, you know, ISAs, cash, insurance policies that have cashed out previously, anything like that, basically money that and assets that you have, including your personal possessions. So if anybody's lucky enough to have, you know, maybe a nice car collection, or even a really lovely car, or they're into their art or etc. So it's basically everything. Now, what's key to that, and again through this process, is getting accurate valuations on all those kind of things. Because when someone passes away in the UK, even if you have a will, you have to apply for what's called grant of permission. So you declare to the court what the assets are, the value of them, and they give you a grant of permission back. And that basically says, okay, you're good to go. Yeah, you can liquidate the estate because you're the executor of the will. Okay, obviously there are some reliefs. You're probably aware of Jeremy Clarkson, and he's been banging on about farmers, for example. So you used to get a lot of relief. Well, it was 100% relief for farms. That's changed now. So it's those types of reliefs that you can get. So agricultural relief has been reduced. You can get certain business reliefs as well. But to be honest, that's probably a very small percentage of the population, shall we say. Now, you can give away money on an annual basis, but it's only £3,000. But for example, that takes it out of your estate, or I think you can gift 5,000 if someone's getting married, a close relative is getting married. So what can you do about it? Okay, touched on it there a little bit. You can give things away. Let's talk about a property, for example. Common misnomer, common mistake. I own a property in the UK, for example, and I decide to give it to my children. So I go to the solicitors, we do all the transaction, and it's now in their name. But I carry on perhaps using it as a holiday home or perhaps live there. That is not taking it out of your estate. So to gift a property, it has to be gifted at arm's length. So if you want to live in that property, have that property available for you, you need to pay market rent for it. And you need to prove that as well. So that's a common misconception. However, you do get a 7-year gifting rule. It's basically starts off as a potentially exempt transfer as long as the person survives those 7 years, and the relief is tapered over those 7 years. So that's a common thing to do. Other things that are going to fall into that net are pensions. And again, it's still draft legislation, but this is going to be the elephant in the room. So SIPs, international SIPs, if you're watching this, if you're living in Spain, you may have a SIP or a QROPS that somebody's advised you on. Now SIPs, 100% will still be in your taxable estate on death. QROPS, potentially not. So QROPS, those people watching this, is a qualifying recognised overseas pension scheme. If it's been set up properly, if it's authorised by HMRC, and they're usually either in Gibraltar or in Malta, they potentially will work. But again, we're waiting for some guidance from HMRC on what that is. Currently, it just says if they are set up correctly. Well, they've been authorised by HMRC originally, so one would think that's a pretty positive route. The other way to look at this, and this has been more of a UK planning tool for many years actually, is insuring that liability. So you can take out plans which are called whole of life policies or universal insurance, which basically insures an asset by paying a premium, perhaps sometimes a lump sum premium, and it's linked to the investments in the, into the markets, etc. So it's going to grow and grow, but it will give you the cover of the liability of the amount of tax that may be due in the future. So again, guys like me will come along, they will look at those assets, they will extrapolate them forward in terms of how much they're going to grow by on average. This is what's happened in the last 20 years, so that's a good average maybe for the next 20 years. Look at the liability and then insure that liability. So a client pays, for example, £50,000 now as opposed to paying £250,000 sometime in the future. So it's a whole of life or universal insurance. Other ways to do this, and again, this is a whole topic on its own and it's going down a more technical route, but you can, if the liability is potentially substantial, open a trust and which really can help protect and gift things down the generations for your family. Again, that's more of a high net worth type of arrangement, but that is definitely possible. Another exemption is charity. It sounds strange. Why wouldn't you give all your money to your next of kin? I have no next of kin really left, unfortunately. We don't have children, my wife and I have one sister, really, that's about all. She's older than me. By the time she's gone, what do I do with my cash? I've got 5 donkeys that I've rescued in the field, so probably some will go to the donkey rescue centre in the UK. I don't really know, but it's those kinds of things. Now, again, this is UK centric, is if you give money to charity like that, a recognised, registered charity, it's exempt from your estate. You don't pay inheritance tax on that. And indeed, it reduces the overall taxable value of your estate at the same time. Okay. There are various other reliefs available as well. Again, getting a bit too technical, but various property reliefs really to encourage kind of that continuity of business. Now, there's lots of changes around that area as well. Unfortunately, really since the government has changed in the UK, there's been a whole raft of changes to taxation. I would imagine Mrs. Reeves will be making some big announcements come the budget in November as well. So some of the aspects for connected people, again, particularly here in Spain, there's first of all, there's a double taxation agreement. So each person is individual. So each person will be different in terms of their asset mix, where they're located. But for example, I'm here in Andalusia. There is no inheritance tax effectively between close next of kin. So if you have family, children in Andalusia, you get first of all, up to €1 million, there is zero. And then after that, there is a 99.9% exemption. So practically speaking, in Andalusia, anybody inheriting, which, a close next of kin, frankly, there is zero to almost negligible taxes to worry about. There may be other taxes, but what I'm saying is in terms of the actual inheritance tax. Now, you need to do that properly. You need to contact the hacienda. You have a certain amount of days to register the inheritance, etc. But there is zero. Whereas in the UK, you might be paying tax on, for example, that property, which is located in the UK, and you can't get away from that as well. So again, various opportunities or pitfalls dependent on where you're residing. So what are the challenges? Well, the usual stuff. Taxation laws varies. I've mentioned there Andalusia. If you cross the border into Portugal, it's different again. If you go into another province in Spain, it'll be slightly different again. So that's a key to it, and understanding individuals' circumstances. Valuations, yeah. Valuations are really important. Again, some assets are difficult to value, but it's really important. Again, going back, if maybe it's a complicated case or it's a specific case, maybe if it's a work of art, well, how do you value a work of art? Well, frankly, you've got to go to one of the big valuation houses like, a Sotheby's and get that valued. And then, of course, you've got coordination with different jurisdictions. You might be living here in Spain and have an international SIP, but that SIP is domiciled in the UK, and that's a different set of rules altogether. And again, that's where companies like ourselves come in, because we've got cross-border jurisdictional licenses almost everywhere in the world. Okay, and that's really important. And if we don't, we'll connect you with somebody who can help bring all that together. Other issues which will be difficult to deal with and potentially hard to deal with in the future is how you record those. We've got here an I-1040 form, which is a US income tax declaration form. And again, going back to that cross-border planning and how you deal with that on the unfortunate demise of the last remaining spouse. But it's try to keep in those things as simple as possible, and pre-planning does really help. There is one thing that's going to happen to us all. We're all going to die, and anybody that tells me otherwise, I think, is a magician, shall we say. Okay, so what can you do? Some practical steps and so one or two little pitfalls for this one. This sounds obvious. You would not believe how many people do not update their will, and especially when they move to a foreign country. So good practice is you should have a last will and testament in every country that you've got assets. Okay, that's good practice, and they should work together. Now, for example, if you're here in Europe, I've got a Spanish will, but it's also written in accordance with English law. So if there are any challenges to that, I can have it heard in an English court. Not that they're any better or any worse, but I'll probably just understand it, or my next of kin would have understood it better, shall we say. But that's always good practice. Okay, I used to live in the Middle East. I had one there written in Arabic, and it was for my property. God forbid something should happen to me. Regular reviews. Clients that come on board with myself, so we're a financial management and wealth planning firm, so they come on board, 6-monthly reviews, annual reviews, whatever that is. I'm always asking, okay, what's changed? What's happened? Have you sold a property? Have you earned some more money? Have you given some to the kids? Somebody got married. It's all those kind of things which keep the process moving along, and it's almost like updating your personal CV, I guess. Something that you put in the safe or put in the file. God forbid if something happens to me, you know, my wife or my husband knows where everything is. Obviously, talking to family, it's a horrible topic. I found it quite difficult when my late mother passed away, and we knew she was passing away. So it's a very difficult topic, but open communication and talking about these kind of things can help the process later on, especially if you've got a complicated family in this day and age. People got remarried, they've got perhaps grown-up kids, they've perhaps got teenage kids, and that's why it's so important to have a will, because again, dependent on where you're living, you might have, for example, forced heirship. Spain's got forced heirship, Scotland's got forced heirship, and many other countries around the world. And obviously making changes to those plans, updating things as is necessary. Okay, common mistake sounds obvious. You know, putting your head in the sand, it's not going to happen to me. I don't have to worry about that. I haven't lived in the UK for 10 years. Oh, but I've got a house there. Or yeah, but I go back every 6 months. But I'm not really a tax resident. How are we going to, all these kind of things? I've heard it all. Dave down the pub has got lots of great ideas about how to avoid everything. But believe you me, it will catch up with you eventually. Undervaluing assets is always a bit of an issue, especially if you're dealing with HMRC. Don't even go there. It's not even worth trying. You just end up with a huge fine, and it'll be up to you to claw back the money. And obviously taking advice and trying to get the best benefit out of what that liability is. So do something about it, basically. So conclusion, understanding tax rules, home country, Spain. It's very similar in Portugal, European countries, how those inheritance tax rules work, making sure you understand what the liability is, don't put your head in the sand, and then doing something about it if you can. If you can't, you just have to, look at plan B or plan C. Now, if it's a property, clearly you could liquidate the property. If it's something similar like that, I mean, so 9 times out of 10, you can do something to reduce that if that's a priority for you. And don't get me wrong, I've met 1 or 2 clients who are quite happy to allow the government to take a big chunk of money from their estate. Not many of them, because they believe it's good for the kind of social good of the country, shall we say. Okay, so that's it from me. You can book a meeting with me here. It is a chargeable event, shall we say. This is a complicated area. It involves a lot of work, but I charge a nominal €50 fee for a session, and that will give you as much backup after that as you need. Obviously, we'd like to take clients on board, and we can discuss that in a bit more detail later on. So if you scan the QR code, that will take you to that link. I am on WhatsApp. That's my number here in Spain, 699-298-292. Robin at robinthornton.com is my kind of email address for the social medias, etc. I think it's just quite easy to remember. And my kind of work address, shall we say, is robin.thornton@holbornassets.com. Richard, that's it from me. 30 minutes.
Wow.
I think a lot
It
there.
is, bang on. Yeah, pretty much. Yeah, a lot of information there. A lot of information. A lot of useful information. And we've got questions, which is great. We'll start. We'll kind of rewind because some of these questions I'm actually thinking of myself. But just to clear up this domiciled versus non-resident or residence-based topic. Paul's asked about the meaning of domicile because he's saying the OED defines it as a country that a person treats as their permanent home or lives in and has a substantial connection with. I mean, I've heard of people moving to Spain, living there for 30 years. They might have retired there, still got a British passport, but for all intents and purposes, that they've lived there, died there, and they've had cut all ties with the UK, but the fact that they've still got British passports or maybe were born in the UK, how,
Yeah. So
how do they nail down if someone?
There's a good, and it's a good point, OECD definition of it, but that's not HMRC's definition of it to start off with. So there are two different things, but domicile starts off from the passport that you hold and usually where your father was born. And there is a domicile checklist, so to speak, on the UK government website. So it doesn't matter where you live. It's, you could be living in Spain for 30 years, but that's not your domicile. Not according to HMRC anyway. And I don't want to get too much into that argument. But it's usually the passport you hold and the country of birth of your father. Now, it is possible to renounce your domicile. It's not difficult. Probably costs 5,000 or 10,000 in lawyers' fees. So, for example, we've seen a lot of American clients renouncing their citizenship, mainly due to perhaps politics in the US and also worldwide taxes. Don't forget the US has worldwide taxes. The Fed levies that on your income globally. So people are renouncing their citizenship, and about 10,000 people a year do that. But then you have to break all ties completely. You have to be very strict with it. I mean, for example, there was a case in the UK where, I forget the name of the case now, a tax case about 10 years ago. Guy had been living in the Caribbean, wealthy gentleman, many, many years, passed away, and HMRC hit his estate with a huge tax bill because, and then it went to court, and things like he was still a member of a golf club. I think he still had a library subscription, if anybody still has those in this day and age. It was simple little things like that, which made him connected to the UK in terms of IHT liability. So, but that's what's changed. So the good thing about that change is it's now going to a residency-based one, which is what it is in, as far as I'm aware, everywhere else in the world.
Yeah, that should make it a lot simpler, shouldn't it? Clear up this grey area of where your domicile is. I suppose it's where your roots are as well, isn't it? Because I know people who were born in South Africa or other countries because their parents relocated temporarily. Yeah. And then they would say, for example, move back to the UK with their parents, which is they're essentially British because they happen to be born somewhere else, but their domicile is the UK because that's where their family were born and from, and just being born somewhere didn't make them domiciled there.
Yeah, and it's not to be confused with tax residency. So, and again, that's a whole new topic which actually we've covered many times. But tax residency, a certain number of days in a year, or centre of your cultural and economic interests. So you can be a tax resident in a country, but spend less than 183 days a year.
Okay, thank you. And then another question from Paul. He's asking, inheritance tax, is it relevant or applicable to assets where they're held, or is it where the recipient lives? I suppose if you reverse that and say, if a UK citizen who is still domiciled, a UK domicile is living in Spain, and they have assets in Spain and the UK still.
Yeah. So it's a good question.
When they pass, because they're UK domicile but they're living in Spain, HMRC is going to levy inheritance tax on their whole estate, Spain and the UK, or just the UK assets, and then they pay the tax in Spain.
Yeah. So again, it depends pre or post April to start off with. That's where the key date of that has changed. But the way it works is that, or the way it should work, is that UK cited assets going forward. So anything, in a bank account. I know a lot of people who still hold, ISAs and investments in the UK and live in Spain, which is a daft thing to do because they're paying capital gains tax on it, etc. That's another topic that we've covered many times. But going back to that question, if the asset is sited in the UK and they've passed away in Spain, and the inheritance, for example, in Andalusia, 0, okay, that's fine. But that UK sited asset could potentially be subject to UK inheritance tax, okay, because it's sited in the UK, even though it's a residency base. That is because if it's a physical asset, yeah, for sure, it's going to be taxed. If it's an ISA or a pension or something like that, yeah, it's going to form part of that estate. But the kind of complexity of it comes in when the beneficiaries are in a different country, because again, without getting too technical here, if you were inheriting and you were living in Dubai, for example, there's no inheritance tax in Dubai, so you would be a beneficiary of 100% of whatever is gifted to you. If you were in Spain and you were in kinship group 3, which is, again, without getting too complicated, 2 or 3, kinship group 2 or 3. So 1 is basically next of kin, your children, etc. Then it's kind of uncles and aunties, etc. There's a whole list that goes down. You would be subject to inheritance tax, not a massive amount, but there would be some inheritance tax. But again, if you were living in a country that doesn't have that, you wouldn't pay any inheritance.
Okay.
So it's a specific thing. Depends on assets.
Not a one-size-fits-all, is it?
Yeah, not at all. Not at
all. The new rules about the residency, you have to be lived outside of the UK 10 years in the last 20. Or if you've lived in the UK in the last 10 years of the last 20. So basically, you have to have lived outside of the UK for 10 years if you're moving now.
Yeah,
if you've lived abroad for 20 years now, if you've been an expat for 15, 20 years, are you automatically now?
Yes. Yeah.
You are. Okay.
That's where the opportunities arise. I'm one of them. I mean, I don't have any assets necessarily in the UK, but if I did, I've been an expat for 20 years, so I'm no longer going to have to worry about Rachel Reeves, coming after my family for a chunk of my estate. A lot of my clients who are long-term expats, Middle East, Spain, all of Europe, will be in a similar situation. So they've got opportunities. They've also inadvertently got opportunities because they transferred their pensions, for example, a long time ago, 10, 15 years ago, into quirks in Malta or Gibraltar, and it looks like they're going to be exempt from estate planning. So as they were originally, actually, in fairness, and then it all changed, and now we're back to almost like to square one again. But they'll be beneficiaries of the changes.
And if you've been in Spain or France for over 5 years, you've been outside the UK 5 years. Is it a case of doing another 5 years? To make it to hit the 10-year level, and then
yeah, exactly. The current and again, it's draft legislation is this 10-year long-term residency test. So is there going to be some kind of taper relief? So if you've been out of the UK for 5 years and you've got UK sited assets, does that mean that you're going to get 50% of the allowance? That is all unclear as yet. As it stands right now, it's 10 years outside. And actually, another good point is 10 complete tax years. It's not 10 complete calendar years. So, UK tax year kind of different, April to, for 12 months. So that's another complication. But that's how it stands at the moment, 10 out of 20.
Okay, another question here about pensions. This is from Stephen. I think he wrote this when you were talking about when pensions are going to be considered for inheritance tax or part of the estate, and what you can do with them when you do relocate. He's asked, does this apply to things like teachers' pensions, not private pensions or money pot pensions? So I guess government pensions and things like that. How are they going to be treated?
Yeah, well, again, it's another good question. When I'll give an explanation is when people still were able to transfer what we call defined benefit schemes. So clients that had worked for, the NHS or government or, even the army and the police. So many years ago, you could still transfer those. And what they did is get what's called a CETV, so a cash equivalent transfer value. Basically, what that is the value of the pension that's being paid out is how much of the 10-year gilt yield does it take to pay that amount out. So we'd get a value, and typically it's usually about 20 to 30 times what the annual payment is. Again, without getting too complicated, if someone's getting £10,000 a year on a defined benefit scheme, that means that the pot of money generating that is a minimum of 200,000 to 300,000. Sometimes it was 500,000 to 600,000, and it's all dependent on the government gilt yield. So the lower the yield, the lower the value of the cash equivalent transfer value. So what we think is going to happen, to answer the question, is that even defined benefit schemes may be valued for inheritance tax purposes. Now, I've no idea how that's going to work, or if it's even feasible to work. And maybe there's some, I don't know, there's some, adjustment for those types of schemes, because typically a DB scheme is like an annuity. It's just going to pay you out as long as you live. There's no like residual cash value. So how does that work? So that is real gray area, but certainly DC schemes, so defined contribution schemes, things like SIPs and SASs and the rest of it, it'll just be what's left in the pot. Now, the big change to this in terms of financial planning is historically, we would leave pensions till the last for a client to start drawing down on, because they were very tax efficient to give to your beneficiaries. It was a good way of passing down wealth through the generation. What this change in legislation is doing is changing those priorities. So now it's more attractive, or it's starting to get a lot more attractive to use your pension money first, perhaps gift away assets, cash, ISAs, if you're from the UK, those types of things, and to reduce your inheritance tax liability. That's if you've got one. Don't forget, again, you've got 325,000, you've got a main residence exemption. Another hand grenade in the pot is you can't have a main residence exemption if you're living in Spain, because it's not your main residence. So those types of things are, again, bespoke on an individual basis.
Okay. Another question here from Stephen, and he asks, do spousal transfers still work if you have a non-dom spouse? I think you referred to this. So I think he's talking about passing things on to your spouse, obviously with no tax.
Yeah, no, they don't. So previously, if you were married to a non-dom, you got a £50,000 allowance instead of £325,000. So in that example, and this is perhaps a cruel way of putting it, but a kind of analogy is non-dom dies, and normally interspousal, there's no taxation. But sorry, a domicile dies and is married to a non-dom. The Canada Tax Office work on this theory that they assume that the non-dom will go back to their home country, which is perhaps a bit cruel. So they only gave a 50,000 allowance. So basically you'd have 325 nil rate band, you'd get an extra 50 on top, but they'd be taxing it at that stage. So the inheritance that non-dom took would be the kind of net estate, because they're kind of assuming that they're going to go back to their home country with all the cash. And they've even now done away with the 50,000 allowance as well. So it's kind of got potentially worse again for UK sited assets. So an example, maybe got a property over there. It's not your main residence. You're not going to get a main residence exemption. So you've got 325,000. And if you're married to a non-dom, that's it. So if you've got a property worth £500,000 in the UK, which is obviously not unusual, you're going to be subject to 40% tax on 175,000. So it's quite a big chunk of change at quite low levels.
Yeah. So just trying to digest all these things we've talked about, it seems if you take Spain, for example, where Andalusia, where the inheritance tax is low between spouses and family, sounds like the best thing to do if you are moving to Spain is don't have any assets in the UK and get to Spain and qualify for inheritance tax there as soon as possible, where you can have all your main assets. Therefore, if you want to pass them all on, you're not. Again, in a nutshell, it's saying move somewhere with low inheritance tax or no inheritance tax, and make sure that you're not paying inheritance tax anywhere else but there.
Yeah, that's definitely one of the angles, but again, it's down to the individuals. That's why people need to get in contact with us. So it's whether they're cited, and whether also there are mitigation opportunities to ensure that risk. So you pay less tax if you don't want to liquidate the asset or move the asset, or maybe you can't. I don't know. Maybe it's written into an irrevocable trust or something like that. So it's a difficult thing to deal with. But yeah, there are those kind of opportunities if you've been out of country for long enough. I mean, certainly for expats that have been away from the UK and they don't have any UK assets other than maybe a bank account, you're subject to IHT here in Spain. I mean, I'm an example. I've been offshore for 20 years. So my liability, if any, is to the Spanish authorities because I don't have any UK sited assets as of April this year, because it's now based on a residency-based system.
Yeah. Okay. I'm sure we could explore other intricacies of this topic for a long time, but we're over time actually. Done. Can you believe we've done 45 minutes plus already? So thank you very much, Robin. Really useful. I'm sure it's triggering questions in people's minds who are watching and thinking move to Spain. So like you said earlier, get in touch with Robin, book an appointment, and make sure you've got all those bases covered. Small request from us at Your Overseas Home: if you found this useful, we'd appreciate it if you left us a review on the review website Trustpilot. Look out on the website for more webinars on not just inheritance and tax, but all aspects of buying overseas. Otherwise, that's it from us here at Your Overseas Home. Thank you very much, Robin. Enjoy your evening in Spain and the warm evening in Spain. Thanks for watching, and good luck to everyone who's moving to Spain. Thank you.